aspirants of the All India Bar Examination Cohort 17-2023, please, anyone can unmute and read what I posted on the screen.
Criminal Procedure Code Virtual Class 13-1-2023 multiple choice question. Indian Standard Time 9:10 p.m. to 10 p.m. Professor Dr. Mohammed Saheb, Hussain.
Good. Yes, without wasting the time, let me come to our shooting. Be ready. And we dealt yesterday 25th question, that is the second schedule, is based on section 476. Now 26th question. The Supreme Court of India in this case held that section 144 CRPC cannot be used as a tool to prevent legitimate expression of opinion. The court further held that section 144 CRPC is not only remedial but also preventive and shall be exercised only in cases where there is a danger or apprehension of danger. The jurisdiction of the section 144 of the CRPC shall not be used to suppress the legitimate expression of opinion or grievances or exercise of any democratic rights. Option A, Gujarat Mazdoor Sabha versus the state of Gujarat. Option B, the state of Assam and others versus Banashri Gagoi and two others. C, Anuradha Bhasin versus Union of India. D, Anil Chamadia versus the chairman Media Advisory. Shoot among the ABCD.
C is right answer, sir. Anuradha Bhasin versus Union of India.
Yes, the C is the right answer. That is Anuradha Bhasin versus Union of India. The above statement of the section 144 CRPC was dealt. Yes, now I move to the 27th question. The primary issue raised in this case was whether a Hindu unmarried daughter can claim maintenance from her father under section 125 of CRPC only up to the time she attains the majority, or can she claim maintenance till she gets married? Option A, Abraham Thomas Puthuran versus Manju Abraham. Option B, Gaurav Malik versus Baby Akshita through mother. C, Abhilasha versus Prakash and others. D, Dilip Sharma versus Swati Sharma.
Sir, B is right answer, sir. Gaurav Malik versus Baby Akshita through mother.
Wrong. Second option.
Sir, D is right answer, sir. Dilip Sharma versus Swati Sharma.
Wrong. Third option is Abhilasha versus Prakash and others.
Prakash and others.
That is the right answer for the 27th question. That is regarding the Hindu unmarried daughter claim maintenance from her father under section 125 CRPC. Yes, 28th question. In Gautam Naulakha versus National Investigation Agency, the appellant was placed under the house arrest, and the primary question in this case was whether the period of 34 days that the appellant has already spent under house arrest shall be counted under the period of 90 days under dash. A, section 164 CRPC. B, section 166 CRPC. C, section 166 CRPC. D, section 167 CRPC.
D is right answer, sir. Section 167 CRPC.
The answer for the 28th question is D, that is section 167 CRPC, is the right answer for the 28th question. Now let us see the 29th question. Section 252 CRPC, conviction on the plea of guilty. If the accused pleads guilty, the magistrate shall record the plea as nearly as possible in the words used by the accused and may, in his discretion, convict him thereon. Discussed in the case of number A. Yes, number 1, Laltu versus Ramlal. B, Premraj versus State. 3, Abdul Nabi versus Ghulam Muttuza Khan and others. 4, B, Balwant Singh versus Harbhajan Singh. Options here given is A, 1, B, 1 plus 2, C, 1 plus 2 plus 3, D, 1 plus 2 plus 3 plus 4.
A is right answer, sir. 1 plus 2 plus 3. A is right answer, sir. 1 plus 2 plus 3.
It is answer is D, 1 plus 2 plus 3 plus 4 is the right answer. All deals with the section 252 of the CRPC. 30th question. In dash, the Honorable Court held further investigation within the meaning of provision of section 173 subsection 8 of CRPC is additional, more or supplemental. Further investigation, therefore, is the continuation of the earlier investigation and not a fresh investigation or re-investigation to be started ab initio, wiping out the earlier investigation altogether. So, options are A, Tahir Hussain versus Assistant Director Enforcement. B, Rama Chaudhary versus State of Bihar. C, P, Guruswamy et Muhammad Ali versus the Superintendent of Police. D, M, Vishwanathan versus State represented by. Shoot the right answer.
B is right answer, sir. Rama Chaudhary versus State of Bihar.
B is the right answer. That is the Rama Chaudhary versus State of Bihar is the right answer for the 30th question. Now, 31st question. Anyone can unmute and read?
That case is popularly known as the IS-ISRO espionage case. Which one it is? Dash. Option A, Mariam Rashid versus State of Kerala. Option B, Sumanu Simha versus State of West Bengal. C, Bhagwat Singh versus Commissioner of Police. D, K. Chandrasekhar versus State of Kerala.
Shoot. ISRO espionage case. There are different people from different countries they are working together there. So they made the espionage. Even though
A is correct, sir. Mariam Rashid versus State of Kerala.
A, Mariam Rashida versus State of Kerala. In that case, yes, it is the ISRO espionage case, popularly known. 32nd question. Which is the latest amendment of CRPC? A, Code of Criminal Procedure Amendment Act of 2020. B, Code of Criminal Procedure Amendment Act of 2021. C, Code of Criminal Procedure Amendment Act of 2022. D, Code of Criminal Procedure Act 2023.
He is right answer, sir. Code of Criminal Procedure Amendment Act 2022.
You are right. The C is the right answer. Code of Criminal Procedure within parenthesis Amendment Act 2022 is the right answer for the 32nd question. Now 33rd question. Yes, anyone can unmute and read the third question.
The Expert Committee on Criminal Justice System Reforms, within parentheses chaired by the Dr. Justice V.S. Malimat, suggested changing the 1920 Act in March 2003 to allow the magistrate to authorize the collection of data such as blood samples for dash within the parentheses with option is the wrong answer. Answer A. Option A, DNA. Option B, hair. Option C, saliva. Option D, ovary. C is the right answer, sir. Saliva.
WRONG.
Option A, sir, DNA.
WRONG. I say, which option is the wrong answer?
Option D, sir.
Option D is the ovary is the wrong option. Then what is the right option there? I removed something and I inserted something. What I removed, it is a sperm. I removed the sperm and added an ovary. Is it clear?
Yes, sir.
Yes,
Good.
sir.
34th question. The Criminal Procedure Code 1861, is it? It is yes. Yes, 1861 was passed by the British Parliament. The CRPC was created first time ever in 1882 and then amended in 1898. Then according to Dash Law Commission report in 1973. Number 1, 41st Law Commission report, B option 42nd, C option 43rd, D option 44th Law Commission report in 1973. Among the ABCD, which is the right answer?
C is right answer, 42nd Amendment.
How much?
B,
Yes,
sir.
sir. 43.
42nd Amendment.
It's wrong. The 42nd Law Commission report, amendment no, 42nd Law Commission report in 1973. If you say the B, it is a wrong option. Second option,
43, sir. 43.
wrong option.
41, sir.
So A is the correct answer. The 41st amendment, that is the 41st Law Commission report in 1973, they made the suggestions for the present Criminal Procedure Code. 35th question. Different types of codification of criminal law. Which option is the wrong option? A. Criminal law in the Vedic age. B. Criminal law in the Islamic age. C. Criminal law in the Mughal period. D. Criminal law in the British period. And which is the wrong option among the ABCD?
A is right answer, criminal law in the Vedic age.
Criminal law,
Law in the Vedic age, sir.
I say wrong option, pick out from the ABCD.
C, sir.
Option A, sir.
Option A, if you say it is taken from the Smriti and other Vedic ages, it is irrelevant. They are taken from the codification criminal law from the Vedic age. Next.
C, sir. Option C.
There is no option C is there. It is I fabricated. Because criminal law in the Islamic age is there. Criminal law in the British period is there. Criminal law in the Vedic age is there. But I made the criminal law in the Mughal period. There is no such a option which is a wrong option. 36th question. Dash made even more changes to the offences of murder and homicide in the early 1800s. For example, the law now made distinction between the intentional and unintentional killing. Who made such an amendments? A. Lord Chelmsford. B. Lord William Bentinck. C. Lord Wellesley. D. Lord Blackwell.
C is right answer, sir. Lord Wellesley.
Lord Wellesley is the right answer. He made even more changes to the offences of murder and homicide in the early 18th century. For example, the law now made distinction between the intentional and unintentional killing. 37th question. Section 265 capital A to section 265 capital L dash pre-bargaining. Options: A. Chapter 11, B. Chapter 11 capital A, C. Chapter 11 capital B, D option Chapter 11 capital C. Which is the correct option? Plea bargaining.
A is right answer, sir. Chapter 11.
WRONG. Wrong. Quick. Second option.
Sir, chapter 21 got, sir.
Is it? Yeah, 21, 21. Yes, you are right, 21, not 11.
21.
Yeah, 10
11
plus 11, 21. 10 plus 11, no, 21. 21 capital A, 20.
B is right answer, sir. 21B.
Chapter 21 capital A is the right answer for the 37th question. So 38th question. CRP is most commonly called dash or dash due to its many chapters. Number 1, monster provisions. 2, huge provisions. 3, monster code. 4, huge code. Options: A. 1 plus 3, B. 2 plus 4, C. 1 plus 2 plus 3, D. 1 plus 2 plus 3 plus 4.
B is right answer, sir. 2 plus 4.
WRONG. Second option.
Option A. Option A.
Option A is the correct answer. It is 1 plus 3 is the correct answer. It's a monstrous provisions or monster code. That is the right answer for the 38th question. Now 39th question. Mismatch. I say mismatch the following. What I said? Mismatch. Okay. 1. Section 300. Person once convicted or acquitted not to be tried for some offense. 2. Section 304. That is power to direct tender pardon. Then 3. Section 307. Legal aid to the accused. State expense in certain cases. And a fourth one, section 311, power to summon material witnesses or examine person present. Here I have given the options. A, 1 plus 2. I say mismatch. B, 2 plus 3. C, 3 plus 4. D, 1 plus 4. I said mismatch. Here, some matching is not there. For instance, you take like this matching proper or not. Like this proper or not matching. Shoot. In my last class, I asked not mismatch. I asked match the following. In yesterday class, same point. But here I twisted it as a mismatch. No one is giving the answer. See, Section 300, person once convicted or acquitted not to be tried for same offense. Section 304, legal aid to the accused at state expenses in certain cases. Section 307, power to direct tender of pardon. Section 311, power to summon material witnesses or examine the person present. So, which is the mismatch? If you closely watch, mismatch is 2 and 3.
Yes, sir.
So, right answer is
B.
B.
Option B,
2 plus
sir.
3.
Option B, 2 plus 3 is the right answer. Yes, anyone can unmute and read. 40th question. Give the chance to other
The
people.
Supreme Court is the dash court of India. A. Zenith. B. Climax. Option C. Top. Option D. Apex. Apex Court of India, sir. Right answer.
The right answer is Apex Court of India.
Yes, sir.
Excuse me. So 41 question. Mismatch the following. 1. Amendment of Section 309 CRPC on plea bargaining. Number 2. Amendment of Section 320 CRPC to rationalize the list of the computable offences. 3. Insertion of the new chapter, that is 21 capital A, to discourage the unnecessary adjournments. And 4. Insertion of Section 436 capital A D for release of the under trial prisoners who have undergone half of the maximum imprisonment. I say mismatch, and here I have given the option A 1 plus 2, B 1 plus 3, C 1 plus 4, D 3 plus 4. Shoot. See, here I have given the options, feedback. Amendment of Section 309 is CRPC to discourage unnecessary adjournment. Next is amendment to Section 320 CRPC to rationalize the list of compoundable offences. Insertion of the new chapter, that is 21 capital A, is on plea bargaining. Insertion of 436 capital A for release of the under trial prisoners and have undertaken half of the maximum imprisonment. So I have shown the options, the feedback. Now you can shoot which is the mismatch among the. Which is the mismatch? I have shown the answer here. Is it clear? Then which is the mismatch here? A or B or C or D. For instance, you take amendment section 309 CRPC to discourage unnecessary adjournment. But what I wrote on the plea bargaining, that means one is wrong. Am I right?
Yes, sir.
Okay, now annulment of the section 320 CRPC I shown. See here, annulment of 320 is to rationalize the list of countable. So here, no, it is not a mismatch. The same one is there. But when you come to the insertion of the new chapter 21A, it says here is on the plea bargaining. And what about here? To discourage the unnecessary adjournment. The right answer
1 plus
is
3, sir. 1 plus 3.
1
Option
plus
B.
3. The mismatch is 1 plus 3. Is it clear?
Yes, sir.
Yes, sir.
The mismatch is 1 plus 3 here, mismatch is. Okay.
Okay, sir.
Now next, 42nd question. Match the following forms from part A and the respective sections from part B. I say forms. These forms are where? Schedule. The forms are schedule 1 or schedule 2? Why you are
Schedule
keeping
1, sir.
quiet? We discussed yesterday. What is schedule 1? kinds of punishments,
Offenses.
and schedule 2 is 56 forms. So the forms from which schedule? Schedule 2. Okay. Now form 40 SM as the following. Form 40, Form 44 and 42 and 47 in part A 1, 2, 3, 4. Part B, A connected to section 442, B connected to section 446, C connected to section 366, D connected to section 421. And here I have given the options. A 1B, 2A, 3D, 4C, B 1C, 2B, 3A, 4D, C 1C, 2D, 3A, 4B, D 1B, 2A, 3B, 4C, and which is the correct match the following among the ABCD.
Yeah. B option is correct, sir. 1C, 2B, 3A, 4D.
Option C is the right answer. It is 1C, 2D, 3A, 4B. Here I have given. Form 40 connected to section 366, Form 44 connected to section 421, and Form 42 connected to section 442, Form 47 connected to the 446. So the right answer is
C is right
Option,
answer.
option C, sir.
C.
option C, 1C, 2D, 3A, 4B. That is the right answer. Anyone can unmute and read this 43rd question. The person who did not read, please read.
How many times English
How many-
words is used in CRPC 1973? Option A 1, option B 2, option 3 C, option D 4.
C is
How many
right answer,
times
sir. 3 times.
English word
Three
English
times.
is used in the CRPC 1973?
C
See,
is right answer, sir. 3 times.
run,
Option B, sir, 2 times.
run,
Option D, sir. 4 times, sir.
run.
1 time.
Option A 1 time.
A option.
Only one time the word English is used in the CRPC 1973 in the entire act. Of course, sir, do they ask such a question? I framed it from the different angle. X-axis, Y-axis and Z-axis, 3-dimensional. Is it clear?
Yes, sir.
Yes, sir.
44th question. Under which section of the CRPC the word English is used? A. Section 277, B. Section 277, Class A, C. Section 277, Class B, and option D. Section 277, Class C. In which section among the ABCD the word English is used?
B is right answer, sir. Section 277, Class C.
Wrong. No, it is the right answer. Section 277, Class C, where if it is the English language and a person doesn't have the knowledge of it, it should be translated. I think in that context it is used over there. Yes, 45th question. The persons who did not read, please give the chance them to read. Today, including me, only 6 persons, even though I started from the 9-10. Read. 45th question.
Section 162 of the Code of Criminal Procedure Code 1973 is for the protection of option A, suspect, option B, respondent, option C, defendant, option D, accused.
B respondent, sir.
Repeat.
B respondent, sir.
WRONG.
Option D,
D
sir.
is right answer, sir. Accused, sir.
Accused. Option D.
Accused is the right answer. Option D is the right answer. Accused. Section 162 of the Code of Criminal Procedure Code 1973 is for the protection of the accused. Why you say accused here? Because it is a criminal case.
Yes, sir.
Yes, sir.
Why don't you say defendant and respondent and other thing? Because it is a civil case.
Victim or accused.
Okay, 46th question. Akshita is accused of disobeying a direction of the law with the intent to save Swati from punishment as per section 203-13 CRPC. A. The charge must set out the disobedience charged. B. The charge must set out the law infringed. C. Both A and B. D. All of them. Actually, I borrowed the idea from somewhere, this one, from the net, but I changed the style of asking the question.
These right answers, all of them.
All of them is the right answer.
Yes, sir.
Because there they said only both A and B is the right answer, none of the above they said. Then I changed from both A and B and D, all of them. So if you tick C, it is the wrong, because D option is there. All of them, you have to tick that one. That means you cannot make any assumptions and presumptions. Whatever the A, B, C, D options are given, from there only you have to choose. Is it clear?
Yes, sir.
Clear, sir.
Anyone can unmute and the 47th question read.
Which of the following states that no appeal shall lie from any judgment or order of the criminal code unless otherwise provided under CRPC? Option A, section 369. Option B, section 370. Option C, section 371. Option D, section 372.
Shoot.
C is right answer, sir. Section
Option D, sir.
371.
372.
Option D is the right answer. Which of the following states that no appeal shall lie from any judgment or the criminal code under otherwise provided under the CRPC section 372? Okay, this is a bigger one, I read it. 48th question. P with 6 others commits the defense. Actually, it is not a defense of writing. Okay, commits the defense or offense of writing. Of course, he took the defense of writing grievous hurt and assaulting of public servant, enduring in the discharge of his duty as such to suppress the riot and applying the section 220 CRPC, because the P is a policeman. Are you following me? Let us otherwise nobody could take the defense. Okay, now A. P may be separately charged with and convicted of offense of under section 147, 322 and 149 of the Indian Penal Code. I did not say no assumptions, no presumptions. Don't think the P is a policeman. Are you following me?
Yes, sir.
Yes, sir.
Just concentrate that P with the 6 others commits actually it is the defenses of writing, not offenses. Offenses of writing, not defenses of writing. It is the offenses of writing, grievous hurt, and so and so. Now here, A, P may be separately charged with and convicted on the offense under section 147, 322 and 149 of the Indian Penal Code. B, P may be separately charged with and convicted of the offense 147, 323 and 150 of the Indian Penal Code. C, P may be separately charged with A, convicted of offense under section 147, 324 and 151 of the Indian Penal Code. Or D, P may be separately charged with and convicted of the offense under section 147, 325 and 152 of the Indian Penal Code, and under which A, B, C, D he will be separately convicted. under the section?
Is right answer, sir. Sir.
Yes.
Is right answer, sir. He may be separately charged with and convicted of offences under section 147, 325 and 152 of the Indian Penal Code within parenthesis 45 of 1860.
You are correct, because riots comes 147 and hurt and assault comes 140, 325, and assaulting the public servant comes under the 152. So offenses committed here, not defenses of rioting. So P can be charged by 147, 324, 325 and 152 of the Indian Penal Code within parenthesis 45 of the 1860. What is this 45? Anyone? Supplementary question?
Act number, sir.
Appreciate. 49th question. Which one is the correct wording as per section 92 of the CRPC? A. Section 92 deals with the procedure for postcards and telegrams. B. Section 92 deals with the procedure for the telegrams and postcards. C. Section 92 deals with the procedure for letters, telegram and fax. D. Section 92 deals with the procedure for letters and telegrams.
C,
Is
correct
right
answer.
answer, sir. Section 92 deals with the procedure for letters, telegrams and fax.
Wrong.
Option A, sir.
Wrong.
Section 90.
Option D is right answer, sir.
Option D is the right
Section
answer.
92 deals with the yes.
Option D, 92, it deals with that procedure for letters and telegrams. But I changed the postcards and telegrams and postcards, and letters, telegrams and fax, and letters and telegrams. What should be the right answer? So now, 58th question. X has in his possession several seals. Knowing them to be counterfeit and intending to use them for purpose of committing a several forgeries punishable under the 466 of the Indian Penal Code within parenthesis 45 of the 1860, applying the section 220 of CRPC. Number A. X may be separately charged with and convicted of the possession of each seal under section 470 of the Indian Penal Code. B. X may be separately charged with and convicted of the possession of each seal under section 471 of the Indian Penal Code. C. X may be separately charged with and convicted of the possession of each seal under section 472 of the Indian Penal Code. And the D. X may be separately charged with and convicted of the possession of each seal under section 473 of the Indian Penal Code. That means 470, 471, 472, 473 respectively given under the A, B, C, D. Should the right answer. Applying the section 220 of the CRPC.
Option D, sir.
Option D is the right answer. I am sure that you are shooting very nicely because you know my techniques. But you should also say why D is right. Answer is, if you happen to see the 473, it deals with some other thing. But see the 472, it deals with some other thing. So more appropriately is there 473 is the right for under the 220 CRPC when you're making the IPC sections. Am I right?
Yes, sir.
Yes, sir.
See, sometimes I saw in many questions, if you use CRPC subsection, at that instance, it is offense only in certain section of the IPC, or it goes together. It goes together. I saw some of the sections. I noticed it. Oh. When this comes, no, this section can be applied in the IPC. Suppose if this will not be there in the CRPC, that section cannot be applied IPC. I saw such an, because when I was reading and framing the questions, I noticed such a thing. One notice I told you, instead of going to the High Court and Supreme Court under the Article 226 and 32, you can tap CRPC provision. They say exhaust the local remedies. I discussed yesterday class. For 51 question, section 211, contents of charge. I also did charge yesterday, but I asked in a different style here. Which option is the correct option? Here, this I am lessly made. Okay. Now, 1. Every charge under this code shall state the offense with which the accused is charged. Lakshman, you can mute it. I am getting some sound from you. When you speak, you can unmute it. Lakshman, you did not? Yes, thank you very much. Number 2, if the law which creates the offense gives it any specific name, the offense may be described in the charge by that name only. 3, if the law which creates the offense give it any specific name, so much of the definition of the offense must be stated as to give the accused notice of the matter with which he is charged. 4, the law and section of the law against which the offense is said to have been committed shall be mentioned in the charge. So 1, 2, 3, 4, I gave it. Now I am asking you, which one is the correct option? Number 1, 1 plus 2. Option B, 1 plus 2 plus 3. Option C, 1 plus 3 plus 4. Option D, 1 plus 2 plus 3 plus 4. Which is the correct option among the ABCD? I committed some wrong in 1, 2, 3, 4. Okay, I will give the hint. I removed certain thing. And that's why one of the 1, 2, 3, 4 is wrong. That means 1 is wrong and 3 are right. I said 1 is wrong and 3 are right. So options are either B or C. Am I right?
Yes, sir.
In option B and C, now you can find it. Which one is appropriate?
Option C is right.
Option C, sir.
Option C, sir. 1
Okay,
plus
I
3, sir.
agreed option C is the right answer. Why? I agreed option C is the right answer. 1 plus 3 plus 4 is the right answer. Why option 3 is the right answer? What is wrong in 2? If the law which creates the offense, see, if the law which creates the offense does not give, I removed does not. Am I right? This does not I removed. Is it clear?
Yes, sir.
So that means when I said does not give it any specific name, so I gave offense give it any specific name. No. So this is totally wrong. Hence, what is the right option? C is the right option. That is 1 plus 3 plus 4 is the right answer.
3 plus.
Because in 1 plus 2 plus 4, I did not change anything. I changed only from the third. So that is the feedback. Is it clear?
Yes, sir.
Yes, sir.
Day by day, I thought the participant may increase it, but I found the participants are decreased even though I reduced the time. Not reduce the time, I preponed it. Instead of starting from 10:10, I made today 9:10. Otherwise, most of the people will be absent. But anyway, even one person also there, it's my commitment that I'll teach. As if there are 100 persons participated in me. So my
Thank you,
life
sir.
ambition will be fulfilled. Perhaps I may be the more beneficiary than you. That is my life goal. So today I prepared 51 questions, and that means roughly. सारे जहां से अच्छा हिंदुस्तान हमारा, जय हिंद।